There's a case pending right now before the U.S. Supreme Court that deserves attention. It's actually a case that originated here in the Eastern District of Texas, where I practice criminal defense law. United States v. Houmani. Houmani was the subject of a federal search warrant. Agents searched his home. They found a firearm, a 9mm. They found some powder cocaine, and they found some marijuana. Part of the investigation, Houmani admitted that he used both of those substances. The government indicted him. One of the counts they indicted him for was 922G3, which makes it a federal offense to possess a firearm if you are either a user or in possession of controlled substances. Houmani challenged that count of the indictment, filed a motion to dismiss it, arguing that it's unconstitutional to deny him his Second Amendment rights to possess a firearm simply because he also possessed controlled substances, including marijuana. The district court, the trial court, granted his motion to dismiss the indictment. The government appealed. It went to the Fifth Circuit Court of Appeals, which is not an easy circuit of appeal court to win in if you're a criminal defendant. I know. I've been there a number of times for oral argument. It's a tough court. They affirmed the district court's decision. They agreed with the trial judge that it was unconstitutional to simply prosecute him for being in unlawful possession of a firearm while at the same time possessing controlled substances. That's pretty astounding. The government didn't like that result, so they took it up to the Supreme Court of the United States. The court accepted the case. It's up on appeal. In March, they had oral argument. The justices were a little skeptical about the theory of prosecution here. They asked whether this person was actually under the influence of those substances at the time he possessed the firearm, and it doesn't appear there was any evidence to that effect. So if the court decides that it is in fact unconstitutional to prosecute people simply for being in possession of firearms and controlled substances without more evidence that they posed some kind of a danger, well, that opens up an interesting debate, because you see, in the United States, it's unlawful to purchase or possess a firearm if you're a cannabis user, which is wild considering almost half of U.S. states have decriminalized cannabis in one way or another. But if you go to purchase a firearm, the ATF question asks, are you a marijuana user? It doesn't ask if you're an alcohol user, even though alcohol is involved with far more violent crimes than marijuana ever has been associated with. But you can possess a firearm, you can buy a firearm and be an alcoholic or an alcohol user. But if you use marijuana, you're prohibited. Now they're starting to relax that. Apparently